Good morning, good afternoon, and good evening, everyone, depending on where you join us. Welcome to this virtual roundtable. My name is Teng, the moderator of today's sessions. I'm a postdoc at the Center for Asian Legal Study, CALS, as we call it here. This roundtable is part of a series hosted by CALS that serve to provide a platform for discussion and exchange of ideas concerning the developments and law in Asian jurisdictions. This is a very special program. Discussion revolves around the book Democracy Under God, Constitutions, Islam, and Human Rights in the Muslim World. So this book was published by CUP in 2023. It tried to answer from the empirical perspective whether the incorporation of Islam in the constitution really is in tension with the protections of human rights, as so many academics and policymakers alike often assume. It is my privilege to introduce our excellent panel today. You can find our speaker's extensive bio in the publicity material that you receive while you register for the webinar. We are thrilled to have one of the authors of Democracy Under God with us today, Dr. Mohammed Zubair Abbasi. We will start with his introductions of the book momentarily. Dr. Abbasi is currently a lecturer at the School of Law and Social Science at Oxford Brookes University. He received his DPhil in law from the University of Oxford and has expertise in many legal disciplines, including family law, corporation law, Islam law, and constitutional law. Dr. Abbasi has held several research positions at prestigious institutions, including the Oxford Department of International Developments and the Max Planck Foundation for International Peace and Rule of Law, Heidelberg. He has also held visiting positions at the American University in Cairo and Punjab Judicial Academy, Lahore. He currently serves as the associate editor of the Yearbook of Middle Eastern and Islamic Law and as editor for Harvard Law School's Sharia Source. Our second speaker is Assistant Professor Ali Shirvani from School of Law of the Northwest University in Xi'an, China. His area of research includes international law, constitutional law, and comparative law. Previously, he held appointment as a research fellow in the Institute of Middle Eastern Study of Northwestern University. He studied law in Iran and received his PhD from Xiamen University, China. Joining us today as our third speaker is a return guest who just participated in another of our virtual roundtable last year, I believe. Welcome back, Assistant Professor Marva Khan. She's from the School of Law, Lahore University of Management Science. She is the co-editor of the university's flagship law journal and the co-founder of the Pakistani Feminist Judgments Project. She completed her LM from Harvard Law School on Fulbright scholarships. Her main areas of interest include constitutional law, human rights, and gender. Her recent publications include book chapters on disability rights and accessible information technology and special court in Pakistan. Last but not least, we have Professor Shamshad, who is also a return guest of this virtual roundtable series. He is an assistant instructional professor in the Law, Letter, and Social program of the University of Chicago. Also, he's an adjunct senior research fellow at CALS. He received his PhD from the University of Washington School of Law. An expert in comparative constitutional law and Islamic law, Professor Fazli has published widely in the field of comparative constitutional study and Islamic legal history. So he is currently working on a book manuscript titled Incomplete Constitutions and Coordination in Deeply Divided Society. This book is under contract with CUP and will be published in the Comparative Constitutional Law and Policy series. So welcome. Let me just briefly introduce our program as well. As just mentioned, we will start with an approximately 7 or 8 minutes introduction by Dr. Abbasi. Then it is followed by the comments of our 3 discussants, each of whom, in the sequence I just mentioned, will speak about 15 minutes. Then we will return to our author to see if he wants to respond to those comments or further share his thoughts on the books in light of those comments. So this part will also last about 7 minutes. So the last 20 minutes also we will reserve for a Q&A. So if our audience have any questions, please feel free to write them down using the Q&A function of the Zoom, and I will read them out during the Q&A sessions. Unfortunately, though, the audience would not be able to ask your question orally. We apologize for this, but in this way, we can accommodate more participants in a more organized fashion. So once again, thank you everyone for being part of today's sessions. Without further ado, I will now hand the time over to Dr. Abbasi to introduce his books today. The floor is yours.
Thank you very much, Dr. Tingley, for organizing this session. I'm really grateful to other organizers and other participants for sparing time for this session. So this is the title of the book, and these are a brief contents of the book. So the main argument of our book could be divided into three parts. So the first part of the argument is that colonial history and political bargaining were pivotal factors in determining whether a country adopted Islam or no, or not secularism in its constitution. Second, Islam has been popularly demanded and introduced into constitutions during periods of democratization and modernization. And lastly, constitutional Islamization has frequently been accompanied by an expansion in constitutional human rights. To concretize this argument, I want to focus specifically on the constitutional history of Pakistan to show that how these three arguments, which are interconnected, play out. For doing this, I want to give you an overview how the legal system in Pakistan try to balance Islam and human rights, and how judges, while deciding various legal issues, try to balance Islam and human rights. And in this way, we would be able to engage with the larger debates about the relationship between human rights as secular and Islam as religious, and to see how they interact with each other, to what extent they conflict with each other, or there are some sort of harmonious point, or there is some sort of convergence. So to start with, Pakistan, I just want to start from the history of Pakistan. So ever since Pakistan's creation as an independent state in 1947, Islam has continued to permeate its constitutional and legal system. From the confines of personal law of Muslims at the time of independence, Islam has become the grundnorm of Pakistan's constitutional system. Curiously, the gradual elevation of Islam in the formal system of Pakistan has coincided with the rise of human rights in the constitutional text and judicial precedents. The joint progression of Islam and human rights in the legal system of Pakistan may surprise a number of authors who associate human rights with secularism and are suspicious about the coexistence of Islam and human rights in the legal system of contemporary Muslim states. Indeed, as the book would show, the rise of Islamic human rights jurisprudence in the judgments of Shariat courts of Pakistan in 1980s and 1990s surprised many legal commentators. These courts articulated the principles of natural justice, such as due process and human liberties, in the language of Islamic legal principles, such as adl, that is justice, qist, that's fairness, and ihsan, that's equity. My research on the constitutional and legal role of Islam in Pakistan suggests that the correlation between Islam and human rights dates back to the time when Pakistan was established as an independent state in 1947 and has persisted ever since. At the time of independence, Pakistan adopted the Government of India Act 1935 as an interim constitution. Since the British Parliament had passed the Act, it was unlikely to assign a constitutional role to Islam in the political order in which Muslims were a minority. But more surprisingly, the Government of India Act did not contain any rights of citizens either. Therefore, Pakistan's first constitution, promulgated in 1956, adopted a variety of fundamental rights. The constitution made these rights justiciable and declared that laws existing or future which contradict fundamental rights were void. The Constitution also declared that laws repugnant to the injunctions of Islam would void, but this provision was not justiciable. Rather than advisory commission was established to make recommendations for taking measures to bring existing laws into conformity with Islam. This constitution firmly established fundamental rights and granted Islam a symbolic role in the political system. The constitution, however, did not last long. In October 1958, the army commander Ayub Khan abrogated the constitution and imposed martial law. Pakistan's second constitution, which could be described as authoritarian constitution, which was adopted in 1962, illustrates that Islam and fundamental rights are closely connected. This constitution did not assign a symbolic role to Islam in the legal system, unlike the 1956 constitution. The 1962 constitution renamed the country as Republic of Republic of Pakistan instead of the Islamic Republic of Pakistan, and tuned down the Islamic repugnancy clause by replacing the specific expression injunctions of Islam with a more broad and ambiguous term as teaching and requirements of Islam. Um, but at the same time, the Constitution marginalized fundamental rights. The Constitution enshrined fundamental rights, but these rights were not justiciable, so they were not enforceable through courts. Therefore, when the Constitution was amended as a result of popular demand, fundamental rights were made justiciable, and at the same time, country was also renamed as Islamic Republic of Pakistan. A similar relationship between human rights and Islam is evident in Pakistan's third constitution, which was adopted in 1973, and its subsequent amendments. The 1973 constitution restored certain provisions of 1956 constitution that related to fundamental rights. It declared that laws inconsistent with fundamental rights to be void and made such rights enforceable through the courts. At the same time, the Constitution also declared Islam the state religion and provided that all existing laws shall be brought in conformity with the injunctions of Islam. This provision, however, was not justiciable, and a Council of Islamic Ideology was established to advise the legislature about the Islamicity of any laws. During Zia's martial law, the 1973 constitution was suspended along with fundamental rights enshrined in it. The Ziaul Haq regime justified the suppression of fundamental rights by enhancing the legal role of Islam through Islamic judicial review. To his dismay, however, the judges of the Shariat courts exercise the power of Islamic judicial review to endorse fundamental rights and basic freedoms of citizens by supplanting these rights and freedoms with Islamic legal principles derived from the Quran and Sunnah. Through endorsement of fundamental rights with reference to Islamic legal principles, the judges of the Shariat courts realized the potential of Islamic constitutionalism to constrain executive authority. It is this potential of Islamic legal principles that inspired the judges of the Shariat courts to enthusiastically embrace Islamic judicial review, even when the military regime of Ziaul Haq actually intended to maintain status quo through judicial Islamization of laws. The correlation between Islam and human rights and their mutually reinforced role in the legal system stands in stark contrast to the general image of Islamization of laws that is closely connected with such horrendous laws such as blasphemy laws, which adversely affect women, children, and minorities' rights. An evaluation of the judgments of Shariat courts shows that the judges softened the rigors of Islamized state-enforced laws. In doing so, they frequently relied upon Islamic principles in this way rather than pitting Islam against secularist Western human rights. The judges of the Shariat courts mitigated political manipulation of Islam with humanitarian and liberal principles of Islam.
Please wrap, Professor Abbasi, because
Yeah.
also we couldn't see your slide. Maybe you could do that later when you're in the session when you respond. Okay.
Okay. So if I may wrap up, so the whole argument is that the constitutional history of Pakistan shows that Islam and human rights, they just coincided with each other. So much so that you can just describe them as conjoined twins. So Pakistan's experience of incorporation of Islam into constitutional system shows that Islamic constitutionalism can accommodate a wide variety of models of political governance. It is because of this capacity that the role of Islam has persisted in the constitutional models of several Muslim majority countries that espouse diverse forms of government. The extent to which ideal of Islamic law inspired rule of law materialize in checking the state authority by serving and protecting individual rights and personal freedoms is determined by myriads of contextual factors, including constitutional design for interpreting Islamic legal texts and enforcement mechanism of Islamic constitutional clauses. So that is it, what I wanted to present. I look forward to hearing from other panel members.
Oh, thank you. That's fascinating. And now I hand time over to Professor Shirvani. The floor is yours.
Hello, everyone. And thank you very much for this opportunity to discuss this great book, Democracy Under God. My name is Ali Shirvani, and I'm from Iran. I studied Constitution of Iran very deeply, and I work on an encyclopedia of Constitution, and know Professor Abbasi from a great article from a few years ago with the same topic, I can say, Beyond Republic or Emirate, Afghan Constitutional System at Crossboard. And thank you very much for this opportunity to discuss the book. I would like to congratulate Professor Abbasi for choosing such a great title, which within the two terms of democracy under God, it has provided some paradoxes such as sovereignty paradox, rights paradox, and legislative paradox, and also judicial paradox between democratic systems and democratic theories and Islamic theories. For sovereignty paradox and right paradox, I think Professor Abbasi in this book had done a great job and provide full cover of the topic. But for the judicial paradox and legislative paradox regarding the Islamic constitution's frequency of the legislative power and also judicial power, it needs more discussion. In summary, this book and its analysis have strengths of much needed empirical analysis of the phenomenon of constitutional Islamization across Muslim majority countries, filling a significant gap in this area of studies. The book developed a novel index, Islamic Constitutions Index, to systematically measure and rank the degree of Islamic provisions in constitutions, allowing for comparative assessment. Also, the historical analysis tracing the origins of Islamic constitution to colonial experiences add a very valuable context and explanatory power. Case studies from countries like Afghanistan, Iran, Iraq, and Egypt offer a very insightful illustration of the political bargaining process behind incorporating Islamic supremacy clauses. The book also takes a nuanced stance, avoiding outright opposition or endorsement of constitutional Islamization, and instead examines how it can be reconciled with democracy, with rights through institutional design. This book makes a compelling overarching argument that constitutional Islamization, far from being an imposition of theocracy, often emerges from political bargaining between secular and religious forces. The empirical data from the Islamic Constitution Index shows that Islamic provisions around half of Muslim majority nations lends weight to claims of constitutional Islamization being a prevalent phenomenon that deserves scrutiny. The book distinguishes itself from other works in its empirical focus and systematic measurement of constitutional Islamization through Islamic Constitution Index. Many previous studies in this space have been either theoretical or limited to single case studies, but this book builds on the work of scholars like Nathan Brown, Clark Lombardi, and Donald Horowitz, who have examined the phenomenon of constitutional bargains between secular and religious forces in nations like Egypt, Afghanistan, and Malaysia. However, by quantifying Islamicity and providing a broader cross-national analysis, this book takes the understanding further. The book thematic overlap with works by Noah Feldman, Khaled Abu el-Fadi, and others debating whether Muslim majority countries can develop their distinctive Islamic constitutionalism as an alternative model to Western liberal democracy. This book's central premise that accommodation of Islam is possible to Western liberal democracy is possible without necessarily undermining democracy aligns with such arguments, but with more empirical grounding. In analyzing constitutional court judgments, the book complements studies by scholars like Moin Kima on how judiciary rulings in countries like Pakistan and Malaysia have sought to reconcile constitutional religious provisions with rights and democratic principles through juristic interpretation. Overall, while building on prior scholarship, the book combination of quantitative measurements, historical experiences, and analysis of political bargaining behind constitutional Islam makes a unique contribution to this field of research. And thank you very much. That's it for now.
Thank you, Professor Shirvani. Now I hand over the floor to Professor Khan.
Hello, thank you. So I think I was try not to sort of be too repetitive, but I think this, when I was sort of reading this book, and I've worked with Zubair before, and he's a former colleague, and I've actually been following Raud Ahmed's work for some time, especially under the Comparative Constitutional Project. And I think this book is quite comprehensive in the sort of overview it gives and sort of contextualizing the sheer variety of Islamic constitutional frameworks that exist around the world. And I think there's 2-3 things in terms of the contextualization, which I feel are very, very important in sort of adds to the charm of the book as well. So when you're looking at the broader concept of Islamic constitutionalism, I think the book does a very good job in, first of all, not just outlining how rights often go hand in hand, or like a large number of fundamental rights often go hand in hand with Islamic constitutions, but more broadly, the concept of structurally limited governments. The idea that when you're looking at democracy, when you are looking at populist politics, when you're looking at what the government can and cannot do, it's not just about how extensively the rights are interpreted or restricted, for that matter, within an Islamic constitutional framework, but also the idea that very similar themes of limited government that you will find in many Western countries, even secular countries, are very sort of deeply embedded within the framework of Islamic constitutions. And sort of taking the roots of where Islamic constitutions are coming from. So the book actually doesn't have a myopic understanding there as well, because they look at the Ottoman Empire and the concept of Siyasa Sharia, the idea that the ruler had to have a consultative body which would essentially guide them regarding all their Islamicity of the various policies or laws that they wanted to enforce or implement, and at the same time comparing that and drawing the roots from colonialism and how different types of colonial regimes have had varying impacts. So the idea that the British colonizers had a very different approach towards the colonies, the idea that they did allow Islam and other religions even to function within the colonial framework, the idea that the British actually were the ones who were part and parcel responsible for codification of religious laws, right? So even now, much of our in Pakistan, much of the religious laws that we have right now have been codified in one way or the other by the British, or at least they spearheaded that sort of codification. And on the flip side, we see the French colonizers and even the Soviets, which the book talks about, and how they had a very repressive approach towards the existence of religion, how they actually directly attacked religious institutions within their colonies. So with particularly the case of Algeria under French rule, and also then subsequently, and how the Soviet Union essentially had an even far more greater sort of form of repression against existence of religion. And that sort of maps out very nicely. So they've sort of tabulated the Islamicity of constitutions where there is a Muslim majority within each country. And I think that was sort of quite eye-opening as well in terms of how former British colonies fare differently with a lot more sort of Islamic provisions within their constitutions often. And the comparison about how in several French colonies, the religious rhetoric actually came as a source of or a rhetoric of anti-repression or anti-colonialism or decolonization for that matter. And that post-colonial approach of the book, I think, is actually quite fascinating and also very unique in terms of the other literature that's out there on such themes. And another wonderful aspect, I think, of the book is the type of Islamic provisions that are mapped out very nicely. And that also goes back to the sample Islamic constitution drafted by the Al-Azhar University. And that framework, so in terms of how Islam can be or the source of law, that's a sort of the idea of whether or not there is supremacy of Islam vis-a-vis other sources of law. The concept of Islamic repugnancy clause, which they've again cited, has been a derivative of the English repugnancy clause that existed within the colonial, within the British colonies. And of course, other Islamic features like the head of state being a Muslim, the concept of having a religiously inclined preamble to the constitution, and even religious consultative bodies. So to sort of linking that with the Siyasa Sharia even, and how they continue to permeate or exist in one way or the other. So Pakistan, for example, has the Council of Islamic Ideology that's supposed to review all laws and policies that the government has come up with in terms of whether or not they're Islamic. But at the end of the day, it's still a consultative body with not which doesn't really file binding sort of rulings, unlike the Federal Shariat Court that came out later. And I think in terms of how the judiciary has approached it is also important, but especially with respect to the case study of Pakistan, I think it's quite fascinating that we were already, so even our dictatorial regimes before they are in the late 70s and the 80s were actually, when they came up with the constitutional framework, they did incorporate Islamic rhetoric within the constitution. They did have fundamental rights, whether enforceable or not, and that had more to do with the fact that we were under dictatorship as opposed to whether Islam was allowing it or not. So the idea that Islam is inherently undemocratic is something that this book actively challenges quite head on. The idea that Islam in many of these post-colonial states has been used as a rhetoric against protection, as a rhetoric for protection of various fundamental rights even. And you find that sort of discourse embedded very deeply within Pakistan's jurisprudence also, where the judges don't side, even though our constitutional rights, Bill of Rights is framed in a sort of very Western fashion. It's not, or sort of global, coming primarily from the global north. But our judges, when they are sort of interpreting those fundamental rights, they use Islam as the original source, where all these rights are actually emanating from, as opposed to looking at the alternative global north constitutions that exist. And I think that sort of overall framework, and then complemented by Zia's Islamization era, has sort of led to a situation where many of our laws, which were, again, like I sort of started off discussing, how they were codified actually by the British, now that they sort of have been given a garb of coming from Islam instead of recognizing the colonial roots. So, for example, blasphemy, which is a crime, and has, of course, been modified during the Zia era as well to sort of expand the scope of what falls within the domain of blasphemy. And it is an active restriction on not only on freedom of expression, but also on religious expression and religious profession or profession of religious beliefs. But at the same time, when our courts are interpreting it, they actually cite Islamic law as being the source of this crime, as opposed to the actual root, which was essentially the first codification of Section 295 of the Pakistan Penal Code, which was then the Indian Penal Code, was done by the British themselves, right? So they were the ones who actually brought blasphemy law in a codified form into the Indian subcontinent. And that sort of disconnect often, I think, is something that the book sort of extrapolates. The idea that all these Islamic countries, or countries where Islam has a role to play within the political and the legal sphere because of how the constitutional makeup is, sort of contextualizes each country in itself as well. The idea that, sure, Pakistan was the first country sort of to be liberated in the name of a religion, or to be created in the name of religion, but when we sort of look at that discourse, we often negate within the political rhetoric the idea that it was something beyond that as well, the idea that it was part of the broader decolonization that was happening around the world, and the idea of liberation from a colonial force. And that contextualization, I think, is also very, very important. So while, of course, the central point of the book is to create linkages between illustrating that Islam is, number one, inherently not necessarily repressive. Islam and democracy can coexist, and just because Islam is a state religion or has a role to play within the constitution does not automatically mean that the country is a theocracy. But also contextualizing all these individual countries vis-a-vis one another to see how then religion practically manifests within the role as well. So I was surprised to see that Maldives has a more Islamic constitution textually as compared to Pakistan, because if you sort of compare the social fabric, it's actually quite the other way around. And that sort of context is also quite illustrative of how similar even constitutional provisions can have varying impacts depending on how the social and political and ethnic even fabric sort of varies from one country to another. So this is pretty much it from me. Thank you very much.
Thank you for Professor Khan. Thank you for helping us to map out and contextualize the kind of original contributions of these books. That's very fascinating and actually aroused a lot of questions that I will need to follow up during the conversation. But now let's hand over the floor to Professor Farsley first. The floor is yours, please.
Yeah, thank you so much, Teng. Thank you, Zubair, for and to Dawood for writing this book. A lot of good things have already been said about the book by Ali and Professor Khan, but I would just echo that this is a really rich book, both in terms of its theoretical sophistication and as well as in its empirical details. The paradoxes, the debunking of the paradoxes that Ali was talking about, the tensions that we've commonly mistakenly, of course, perceived between human rights and Islam, and whether constitutions that kind of enshrine Islam would then threaten democracy or not. I will, however, ask a couple of questions as a way of moving this conversation for the remaining of the time forward, and perhaps thinking more broadly about about the research agenda I think that this book sets. Obviously, the book makes fascinating claims and points and hypotheses. A lot of them have already been said about the colonial influence on this constitutional Islamization. And one that struck me was the idea or the thesis that the demand for constitutional Islam or for including Islamic supremacy clauses within constitutions tend to occur in popular moments. Or in other words, as the book puts it, a more open democratic space, a participatory process, then creates this room or this demand for including Islam within constitutions. And that was obviously the case in a lot of the countries in the Arab Spring. And when we go to chapter 2 of the book, and there's my question as a point of discussions. Chapter 2 is what I thought was the demand for incorporating Islam has always existed throughout history. When the book traces the origins of Islamic supremacy clauses, it seems that the debate was there, or the demand, as the book puts it, was there that Islam must be or should be included within constitutions. And when you discuss the Constituent Assembly of Pakistan, the debates were there. Syria, which is the first constitution that enshrines the Sharia supremacy or Sharia guarantee clause, as Clark Lombardi calls it, as the source of legislation, the debates were there. Afghanistan, which is one of the case studies during the drafting of the 1923 Constitution, was the first written constitution. The debate was there that the constitution written needs to incorporate Islam. So my question was, to what extent the popular what is different within these popular moments, like the Arab Spring in 2011, that kind of creates this renewed demand or some stronger version of demands for incorporating Islam? And where do you fit a country like Tunisia, where a participatory process kind of created room for more secular forces that kind of rallied against Ennahda, the Islamist party's agenda, to enshrine, to include within the constitution, the 2014 constitution is gone now, a clause that would make Sharia as the only source of legislation, but because of resistance, that was kind of given up at the end of the day. That's point number one, as a broader, as a conversation starter, to kind of think about what really is different in these popular moments that creates these demands, and how are these demands kind of different from the ones that we see already embedded within written constitutions, as well as within founding moments when Islamic constitutions are written. My second point is, I must say that there's both of you in the book does a wonderful job in defining Islamic constitution. What really is an Islamic constitution? I have always been puzzled by by defining, like, how do we define Islamic constitution? If I'm correct, the book defines it as Sharia compliant constitutions that are compliant to Sharia. So some define it very broadly, some define it very narrowly. Clark, Lombardi, and I wrote an article recently where we defined it as what is an Islamic constitution. We define it broadly to refer to any constitution in which Muslims try to incorporate the lessons about ethical governance that they believe God has laid down in scripture, and to realize the possibility of Islamically legitimate, ideally democratic governance. I don't have anything about the definition of Sharia compliant constitutions will make a constitution Islamic, but my question, the second point that I wanted to make, is how does that fit into the question of measurement? Do the idea that one of the interesting points that the book makes is we have more Islamic constitutions and less Islamic constitutions based on the number of references that you have so brilliantly coded within the book that can then give us some hints about how do we define it and how do we then measure it. My next point is also about the question of measurement, and I think this is an important one, and this is something that will require us to kind of think about it. The idea of counting provisions or references to Islam, whether that is the right or the right metric by which to measure the Islamicity of a constitution, or to find out or to define whether the Maldives is as a constitution more Islamic than Pakistan's, or it's the other way around, whether Afghanistan has a more Islamic constitution than, let's say, Iran. But here's the point: some constitutions say that, and that was the case at least definitely in some of the constitutions that were written in Afghanistan, say that not a single provision of this entire constitution should be against Islam. So how many references do we count that? Is that a one reference to Islam? Is it, I don't know, the Constitution has 200 provisions that makes references to Islam. So when I was reading that, though, I really enjoyed reading the measurement and to see which country has a more Islamic or less Islamic constitution, and how we kind of make a more confident judgment about country A has a more Islamic constitution than country B. But what about a provision that says nothing within this constitution should be against Islam? Is that, if that's one provision, is that a less Islamic constitution than the constitution that has 30 references as the model the Al-Azhar has on it? And the same applies to state religion. Islam is the religion of the state, which I thought that your empirical analysis found that was one of the most common provisions or Sharia guarantee clause or Islamic supremacy clause that existed in many Muslim constitutions. So what does that really mean? I know I acknowledge that you make this very clear that we are interested in the text, and we have deliberately taken a step back from how these provisions operate in practice. But the question then becomes, if a lot of constitutions, as you know this, says that Islam is the religion, that it should be the official religion of the state. And that constitution may not have a repugnancy clause or a Sharia source of legislation clause, but it will be interpreted in a way that the official religion would imply something like that. And this is what courts in some places have kind of interpreted those types of clauses, that if the state has an official religion in its strong establishment sense, then your laws, legislations must not be repugnant, or either should look at Sharia as a source or use it as a guide. So that kind of then spills over to the other parts of the Constitution, which may not necessarily have a reference explicitly within it about Islam, but it will be covered under this broader umbrella of Islam as the religion of the state in its broader, is in a stronger sense. And this then brings me to the question of the idea of should we think about the operation of these clauses in actual governance or not? Should that count? Give us some hint whether a constitution is Islamic or not, more or less Islamic or not. And this brings me to my final point, which I think is important. Now, there's one thing that is often mischaracterized, to say the least, about Afghanistan's first written constitution, the 1923 constitution. So a lot would say like that was a very modernized constitution, a constitution that did not pay a lot of attention to Islam, a constitution that was less Islamic as compared to the other constitutions. But that is not the case. The idea in the drafting of that constitution was this, like, no, this constitution will incorporate Islam, and it did. Not the official madhab, which then was amended, but here was the main debate. It was a king that many call a modernizing king or Western influence, which again is open to debate. But it is, you have a king who is influenced by the modernist trends in Islamic political theory. He says that, all right, we will enshrine Islam. We would say that the legislature should look at Islam in the requirements of time when they make laws. But here was the main debate. The heart of the debate was this. It was the king saying like, well, I will decide what Islam requires. It will be me, the state, saying that this law is consistent with Islam or not. Not the independent religious institutions or the ulama saying that, okay, no. So the king was trying to basically take this power from the ulama. Had nothing to do with the constitutional text. The constitutional text did say we will respect Islam. Each law that the king adopted, the 160 pieces of legislation that the king wrote, at the end of 80% of them, he said, or his legislative council said, that this law has been taken from Hanafi sources, and this is consistent with Hanafi sources. But the problem was this, like it was the king saying it's consistent with Hanafi sources, whereas the religious establishment that had exercised this power historically felt threatened by it and said like, no, you cannot take that power away from us. And it was this coupled with several other factors that kind of brought the king down. And this is very, the debates when the constitution was amended to make it more Islamic is quite telling. One of the changes that the Loya Jirga, the Constitutional Amendment Convention made, but was not written within the constitution, was the king had a modernist religious institution where you have a body of ulama who were trained in modernist trends in the subcontinent, who interpreted Islam obviously in a more liberal way. Whereas you have this very traditional body of the ulama to whom the ideas and the views of the classical jurists of Hanafi school was sacrosanct. You cannot touch them and change them. So one of the changes they make is like, okay, get rid of that modernist committee and we will put these traditionalists in charge of the interpretation of Islam. So again, this brings me again to this question of what about interpretation? To what extent interpretation is actual operations? Like to what extent we should take that into account a little, or at least to some extent, to make those judgments, to make those calls whether a state's constitution is more Islamic or less Islamic. Again, I would conclude by this, that I acknowledge that, I see that clearly stated in the book, that we are interested in text, not in actual operations. But the question will be then, should we, or would it be helpful and more productive to think about operations as well? I have one final thought, Teng, if I can make it.
Oh, please go
I'm
ahead.
already on 15 minutes, but if I can have 1 minute, I will make one final point.
Well, please go ahead. Yeah.
Yeah, and that is about this fascinating discussion about colonialism and how the repugnancy clause was kind of, to some extent, had parallels within the colonial laws, the colonial British laws. What kind of practice should or should not be repugnant to the imperial laws. But the understanding of the repugnancy clause is the doctrine of siyasa sharia, that the ruler is allowed to make legislation to some extent, but within the bounds that they should not contradict the settled or favored opinions of the school. So I thought like these origins went way back to the maybe 13th century, 12th century, in the work of Ibn Taymiyyah and others, who came up and articulated this doctrine of siyasa sharia. So this origin of Islamic constitutions I'm just highlighting this, may go back to there, and that's continues to influence some Muslim constitutions. Yeah, I'll stop here. Please feel free, Zubair, if you want to respond to that. But these were the questions I highlighted just for us to keep the conversation going.
Thank you, Professor Farsley, for proposing all these very fascinating questions. Actually, I have something that is, because what you said, something that is related to what you said, and it's a kind of a question of my own. So I would like to use my moderator privilege to kind of interject my questions here, if you don't mind. So related to the point about how to measure the Islamicity of the constitution. Actually, there's a fascinating chart in your books that there you compare the Islamic index, the ranking of Islamic index and the rights that is mentioned, right? The kind of number of rights that is mentioned in the constitution, and I find it so. So your conclusion is that there is not a really like a necessary strong correlation, but you mentioned that if there is a high in Islamic ranking, then if there is a low Islamic ranking, then the right usually will list more. But my question is, well, but this is just word that were mentioned in the constitutions, right? But when it comes to the enforcement of those rights, right? How how they interpret those rights, right? So because you mentioned that many of these constitutions, half of this Muslim majority country have this constitution that have this Islam supremacy clause, right? So then if the interpretation, well, at least from according to the constitution, if the constitutional interpretation of this right has to come in a way conform to the Islamic value, then I mean, even you have a number of really, you have a lot of rights, but all this right, when it comes to interpretation, it has to conform to Islam. But then whether you say this is like a high Islamic in terms of ranking or so I guess I'm just a little bit puzzled about how to measure it, and also it would further complex by the questions that Professor Farsley just mentioned about who is interpreting this, right? Whether it's the religious leader who have the final authority to interpret, and even the court have to defer to it, or whether it is something that is finally reserved to the state, so the state can contradict. So there's a lot of these kind of complexions in practice that I'm very curious about how you kind of factor into this ranking and come up with this index. But it's really, really fascinating. And may I just say one more thing that is logistic to remind our audience that if you have any questions, you could try to put it down in the Q&A functions, and I'm going to read it out momentarily. So now let's hand back the floor to Professor Abbasi to see what you like to respond. Thank you.
All right, so thank you very much, Ali, Marva, and Shamshad and Teng for your excellent comments. So basically, you have raised 6 points, and if I may to divide them, the crux of your points is that we have this ideal about Islam and human rights, and then what about their enforcement? Or what about the practicality? So writing Islam would be the state religion, have repugnancy clause, and fundamental rights and freedoms would be protected is one thing, but putting them into practice is quite another thing. So we may have ornamental constitutional provisions, both with respect to Islam and human rights, but with no practical implications whatsoever. So that point is well taken. So what we try to do, and that was as a result of external reviewers' comments on our manuscript. So the final chapter that was added about Pakistan and Egypt, looking into that how judges apply them, was a result and actually addressed that particular issue. Of course, I won't be able to go into details, but let me just very briefly touch upon each of the questions. So the first one, the relationship between popular demand in different historical eras and its relationship with the Islamic provisions. So Shamshad, you're absolutely right. Sometimes it's not popular demand, rather it's the dictator who uses Islam, manipulates Islam, and try to legitimize their legal their rule. So that point is very well taken. What we learn from Tunisian de-Islamization, if we may call it, that it tells us something more when people talk about Islam. So okay, people want Islam, but what actually they want? They actually want better governance. They want economic development. Basically, they want food, right? They want bread. They want shelter. So they want the basic necessities of life. So when we further probe, but okay, you want Sharia, but what do you mean actually? So they would just say, by Sharia, we mean that there is no corruption, there is a better governance, and poor and weak people are taken care of. So I think your first point is very well taken, but I think we just need to probe further. What does Islamic provisions actually mean? And what does it say about governance, about empowerment of weak and vulnerable members of the society? Second one is perhaps quite complicated. What is Islamic constitutionalism? My personal view, of course, it was a collaborative project about Al-Azhar constitution. From constitutional perspective, it's not a constitution. If you have these provisions which are very aspirational, so Saudi constitution, Quran and Sunnah is the constitution. Well, it's not constitution. It's your belief that you're expressing. We respect your belief, perfectly fine. Yes, Quran and Sunnah is your constitution. But when it comes to enforcement, governance, separation of power, putting checks on authority, ensuring that different sections of the society are represented, then it's not a constitution. So then it takes me to the third point about miring the constitution. That is really tough, and Teng, you have rightly pointed out that, oh, having these things in the constitution, but then how do you make sure that they are enforced? So here I had a bit of a discussion with my collaborators. There could be alternative indexes. And we do have, I want to draw your attention to Hussein Askari, who's a professor at some American university, his book, Islamicity Index. It looks into values rather than the provisions. So the values, what are Islamic ethical values? Ruler must be just. There must be provisions made for the poor and downtrodden. And ethical value of care, about nurturing and taking care of the people who are weak and vulnerable, such type of values. And based on that index, he does not simply test Muslim countries, but all the countries. And look what countries go on the top: Ireland, Scandinavian countries, even Israel is a top. So in top a top level, there is hardly any Muslim country. So there could be an alternative index. And I think, Shamshad, This is something you're working on, so that is something you may look into. Fourth point, who speaks for Islam? This is perhaps the key. So who has the interpretative of Islam? So writing down Quran and Sunnah would be the constitution, but then who will tell us what is Sharia? Yeah. So if it's the king, then it means actually this is nothing. So whatever king says become the word of God, and that is something Ali Shirvani may tell us about what happened during first 10 years of Khomeini in Iran. And there was lots of tussle, and Khomeini then ended the debate saying that I am the state. So whatever I say is the law is the law. So you have to accept it. So I think that's why example of Pakistan is very interesting. So here, the interpretative authority over Islam is not assigned to a particular institution. Rather, it is distributed amongst several institutions. So we have Council of Islamic Ideology, which has advisory role. It can advise the legislature whether a particular law is Islamic according to Islamic injunctions or not. Then we have Federal Sharia Court. Its judgments are enforced, but its jurisdiction is constitutionally defined. It cannot review the constitutional provision. So constitution itself is taken out of its judicial review. So another institution which interprets Islam. And then we have the legislature itself, which assisted by the Council of Islamic Ideology. So in this way, after this book, my other work explore that how different countries distribute interpretative authority in their institutional structure. So while Shamshad mentioned that king said, oh, Islam would be the state religion and there would be Islamic provisions, but what is Islam? I will decide, right? So in terms of, I think we have looked into different Muslim countries, and that is something that could be brought further. A repugnancy clause, I think, Shamshad, your point is well taken. This is something I need to look into, to what extent Siyasa Sharia is actually about repugnancy clause. But the context of our book is to look into a repugnancy clause within the structure of modern nation state. So here, I don't want to emphasize the distinction between PD model and model, want to go into misleading scholarship of halak, where state did not exist before colonialism, right? That's just is more of ideological argument. I won't go into details, but just want to mention that the Islamic separation of power is that separation of power is between ulama and ruler. So rulers are the enforcers of Sharia. Ulama are the interpreters of Sharia. But then, as we know from Ottoman Empire, ulama were incorporated into the state bureaucracy. So you had Sheikhul Islam. Now state had sort of monopoly on interpretation. So that one. And finally, Teng's point about enforcement of Islamic rights. So this is, I think, the key. Yeah. So I think you're really spot on. Putting all these provisions just for the consumptions of academics, is that what we are looking into? So I think that's where looking into the judgments of the court becomes really important. And what we have done in our final chapter, when we looked into the enforcement of Islamic repugnancy clauses in Pakistan and Egypt, we just see that there are mixed results. So sometimes blasphemy laws are strictly enforced. They are taken in Egypt in Professor Abu Nasr's case, right, who was charged with a blasphemy offense, and its enforcement in Pakistan, it just yields very mixed results. But one thing we can say with confidence, that judges were able to sort of soften the rigors of such draconian, I must say, laws, such as blasphemy laws, by interpreting in a way that the political manipulation was sort of regulated. Just want to give you example of Pakistan's blasphemy law. the law as it's on the book and it's been presented by a traditionalist scholar is that it's a strict liability offense. You just do anything which is blasphemous. There is no requirement that any mana fide intention, mens rea need to be accepted. So it's a strict liability offense. But Pakistani courts, specifically the Federal Shariat Court, even when it reviewed the law and said that, look, the only punishment for blasphemy is actually capital punishment, still clarified in express word that, but mens rea and repentance are the main parts of this law. So if a person did not have mens rea, and if a person after committing this offense repents, then there would be no penalty. So this just shows that how even a very draconian law of strict liability is interpreted. So here, I think, goes back to the whole issue that, oh, having Islam and human rights, but the main point is that who has the interpretative authority? What's the constitutional structure? How the interpretive authority is distributed amongst different state institutions. So that is it, and I look forward to further questions.
Well, thank you for this further elaborations of your methodology in a way, and how you navigate through this very difficult kind of try to come up with like a coherent kind of methodology on factoring this very complex issue. So I have one question here now from our audience, Risa. And she said, I'm reading it out. So thank you for this wonderful discussion. I wonder if I can ask the panel to comment a little further on gender rights and Islamic constitutionalism, and specifically the status of gender equality and non-discrimination provisions as interpreted or understood by courts such as the FSC or SCC in Egypt. So she also mentioned that this question is particular reference to chapter 5 of the books. So, yep.
Yes, thank you very much. This is fascinating. And I think it's just great that this question is asked. Now, after this book, my next project is that I look into all the judgments given this Pakistan's Constitution Code, Federal Shariat Code. Its mandate is to look into any law and see whether they are in accordance with Islamic injunctions or not. So when I looked into about 45 years of jurisprudence, gender equality is something that the courts have endorsed time and again. I just want to give you some examples. In 1980, one petitioner brought a suit before the court arguing that females could not be judges of the courts because according to Hanafi fiqh, females could not be witnesses and they could not be judges. And the court says, no, there is no gender discrimination in Islam. Females could be appointed as judges. That was 1980. Then we had a colonial law. So Marva had mentioned a colonial history in Indian Penal Code, that's called in Pakistan, Pakistan Penal Code. In a rape trial or in a trial for any sexual offense, the defender could impeach the character of the victim. And if it was found that the victim did not have high moral character, and it was described as there was a specific term that was used in judgment, had loose virtuality, had loose virtue, right? So did not have very good character, that could give the defendant some sort of leeway when it comes to establishing the offense and also the extent of the punishment. So it was Federal Shariat Court which reviewed that particular provision of colonial law and say, this is against Islamic law. So you cannot impeach the personal character of the victim, who in most of the rape or sexual offenses happen to be female. And third one, that is about nationality laws. So Pakistan Citizenship Act 1951 provides that if a Pakistani woman marries a foreigner, husband will not get nationality. That affects lots of Afghan nationals who are in Pakistan. So it was Federal Shariat Court which looked into that law and declared it that it is repugnant to the injunctions of Islam because Islam does not make any distinction between husband or wife when it comes to citizenship rights. Now, unfortunately, that was too good a judgment for the state to accept it. So even when this judgment was given in 2007 and 8, it has not still been enforced, and it is unlikely to be enforced. So here is something which is clearly declared as repugnant to the injunctions of Islam, declared un-Islamic, but it does not suit the political conditions. Even Imran Khan's government, they wanted to give Afghan migrant living in Pakistan citizenship rights, and one of the ways to get citizenship is through marriage. And that law, Citizenship Act 1951, was declared null and void and un-Islamic by Federal Shariat Court about gender equality. Finally, about divorce rights, there, I think Federal Shariat Court played very important role in its 2014 judgment. In Salim Ahmed, Federal Shariat Court held that when it comes to right to dissolution of marriage, in Islam, these are the words of Justice Fida Muhammad, that there is no distinction. So there is no disparity. There is equality between husband and wife. As husband can divorce without the consent of the wife, wife can also divorce without the consent of the husband. So these are some of the views. But one final thing, and that's related to Teng's point. My forthcoming paper is about looking into, all right, so we have Islamization in Pakistan starting from 1980, but who are the winners and losers? So what actually happened, right? So what was actual impact? So what I did, not only I looked into the judgments, but also looked into what followed after the judgment. If the court declared a particular law un-Islamic, did the legislature then finally change that law? And when that law was changed, what impact it had on rights of citizens? And there I find that in a summary, in total, Islamization strengthened the stretched rights. So Islamization strengthened the landed and business elites in Pakistan. And it did not have any positive impact on workers and minorities. So what Islamization did is it actually reflected distribution of power in the society. So it was replica. Just one example, as a process of Islamization, state officials, bureaucrats got more rights. So they got right not to be dismissed without notice because that's against Islamic due process. They also got right to be receiving their salaries when they are suspended if there is a disciplinary action going against them. But what Islamization did not do that, it did not change Pakistan's labor laws, which were colonial history and they are anti-worker. So Islamization strengthened the bureaucracy, which was already powerful, and it did not have any positive impact where it could have, that is on women and workers and on minorities.
Oh, thank you, Professor Abbasi. I know that Professor Khan has something to follow up. You've been very patient. Please go ahead.
Thank you so much. So I think Raisa's question is something that goes like very close to my heart, because there's a whole course that I teach, which is called Constitutionalization of Gender in Pakistan, and sort of sees how the constitutional framework sort of embodies gender binaries within our legal system. And also, as being the co-editor of the Pakistani Feminist Judgment Project, is something that we're working sort of quite hands-on with. And I do agree with Zubair in the sense that, yes, you have all these positive judgments sort of coming from the Federal Trade Court, but like 2-3 caveats that I would like to give. Number one, the Federal Trade Court is not the only court that uses Islamic rhetoric as part of the judgments. Every other court, so all your constitutional courts, your civil courts, criminal courts, they all sort of embody within them their judgments, various Islamic tenets or quoting either from the Quran or quoting from the Sunnah, and that's something that's pervasive across our jurisprudence, number one. So when we're looking at gender relation with the Islamic aspect of the constitution, so again, we're not sort of, I think it would be I mean, that could be one area of focus, how the Federal Shariat Court looks at women. But the broader focus, I think, should also be the idea how the judiciary overall is sort of treating gender roles. Focusing on the Federal Shariat Court, so for example, the women, and I think Zubair mentioned this also, women's ability to serve as judges was contested, and the Federal Shariat Court upheld it. Women's ability to serve as the prime minister in the time of Benazir Bhutto, and being even members of the legislative assemblies was also contested, and the petitions were set aside. But I think the reading of the text of the judgment is also very important, and not just like looking at the outcome, because when you see that the judgments are quite long actually, and they do sort of reinforce the supremacy of man over women. And the Federal Shariat Court tends to do this time and again. So even when there was a petition which challenged surrogacy in Pakistan because there's no law on it, and they banned surrogacy. But while doing that, and you can sort of, contest the outcome in many ways, but the line of reasoning that they use is, number one, they referred to women as agricultural fields, while sort of considering the status as a surrogate, or, whether or not they can have children and things like that. They also essentially referred in that same judgment to women as sheep and the man as a shepherd. So that dehumanizing aspect of these judgments is something that comes up time and again. So even judgments which are actually often lauded by, even by the civil society as being very progressive, but purely because of the outcome, I feel the language that they use is, number one, very regressive and also quite misogynistic. Secondly, when you look at gender from a broader point of view, so you just step outside the man woman binary, the Federal Shariat Court has actually in the last year passed a very, very problematic judgment. So earlier on, there was a judgment, Aslam Khaki versus SSP Rawalpindi by the Pakistani Supreme Court, and that essentially for the first time granted rights to trans and gender non-binary persons in Pakistan, because before that there was no state recognition of any third gender basically. And the Federal Shariat, and then that was followed on by Trans Persons Rights Act, and that essentially was set aside as being un-Islamic by the Federal Shariat Court. And their main criticism was that this allows, gay marriages, even though it doesn't. The Trans Persons Act does not grant the right to marriage to gender non-binary persons. So that sort of conflation of what is Islamic and un-Islamic and immoral, essentially sort of finding its way back over there as well. So I do think that, and even if you look at something like conjugal rights, that's a law that was introduced in the Indian subcontinent by the British, but all the recent cases that you find on conjugal rights, you find judges essentially saying that this is an Islamic law, and therefore the man has conjugal rights over his wife, so as long as he stays the wife, he will have access to these rights, right? So I do think that the harm, and I think I sort of mentioned this earlier as well, the harm of Ziyad Islamization era particularly was that now people feel that anything that is part of our legal system, even when it has colonial roots, even when it's not coming from Islam, gets conflated as being Islamic law. And regardless of how problematic it might be, vis-a-vis gender relations and various other aspects, you have like other rights-based, jurisprudence. I mean, some is progressive and other is not. And either way, whether it's progressive or aggressive, Islam is often used to condone that sort of outcome. So Islam, right at this point in time, I think has moved beyond a religion. It's more of a political tool, often used for suppression of political thought, suppression of social, political, and economic rights even. But yes, those were my 2 cents. Thank you.
Oh, thank you, Professor Khan, for offering your insight from a more or less like a historical and also critical gender approach to help us complete the understanding of this process, how it affects, the other half of the population. Is there any follow-up comments from our panel on this particular issue? Okay, and then I would follow. I would move on to the next questions.
So just one thing. I think
yeah, sure.
about gender. Federal Shariat Court, I think Marwa is very spot on. There are judgments which are regressive, and of course, language that's used is also regressive. And important to point out that Federal Shariat Court did not have a female judge. There was only one female judge who happened to be the wife of the Chief Justice of that time. So it seems she was just moved to the Federal Shariat Court simply so that the Chief Justice and his wife should stay at the same city in Islamabad. And to the best of my knowledge, she did not write any judgment. So the Federal Shariat Court, all the reported judgments are written by men. So that's a fact. And conjugal rights, yes, in Pakistan we have this provision that's also in India and in South and Bangladesh. That's called restitution of conjugal rights. That was a common law remedy which was available to one of the spouse to force the other spouse to live with them. But that actually meant primarily men forcing their wives to live with them. And if they refuse, so court could issue an order and even confiscate their property. And that was challenged before the Federal Shariat Court. And Federal Shariat Court says, look, this is not un-Islamic. So interestingly, the same provision was also challenged before various Indian high courts and Supreme Courts, that this provision was against gender equality. It was used against women. And there, Indian Supreme Court says that it's not in contravention of any of the fundamental rights of the Indian Constitution. And I have been working with some of my colleagues to challenge that provision on the basis of fundamental human rights and Islamic repugnancy clause, and to take it to a high court rather than taking it to Federal Shariat Court. So I think that point is very well taken. And I do hope, Marva, you keep that in mind, and that is something that could be done. So I actually had a provision and a petition drafted, and we're waiting it to be submitted at some point in time.
Thank you, Professor Abbasi. My next questions here from the audience is specifically directed to Professor Pasarlay. So the question is from Lee Chen Han. He or she asked, could you please interpret the back to 13th century theory a little bit more? She says she's a little bit confused of what you said by the origin, that's related to the last part of your comments.
Yeah, thank you, Zubair, for the reactions. Understanding Siyasa Sharia and Zubair is here requires you to understand what Islamic law is, how it's interpreted, with the diversity within schools, even the preferences within juristic opinions and anything. So that's like a sea of information. But the gist of the repugnancy clauses, as is so vividly articulated in the book, that many countries, but currently I think it's Iran and Afghanistan, or not even Iran, which has a repugnancy clause, says that Afghanistan used to have it. No law can contradict either the principles of Islam or the basics of Islam or the beliefs and provisions. So the wording differs, but the idea is the same. So there's a doctrine within Islamic political theory, which is called Siyasa Sharia, which literally translates as to governance according to Sharia. So the doctrine says that a Muslim ruler has the right to determine, or has some discretion and freedom to exercise when it comes to deciding how Sharia should be administered. And for that, the ruler will make rules or legislate or draft laws. Of course, laws that are not directly rules that are not stated within the settled sources of Islamic law, even within this vastly diverse body of juristic opinions. So if it's not there, then the ruler can legislate or can make law. So there's the make law, but to the extent that these laws do not violate the Sharia, then what norms of the Sharia is then becomes a different debate. So what I was saying was maybe, and this is within the work of his famous Islamic jurist Ibn Taymiyyah, who wrote a thesis on this doctrine, Siyasa Sharia, in the 14th century. So I say 13th century, but I think it was 14th century. Maybe the treatise was published sometimes in 1330, 1333, something, but it was 14th century. So that was the doctrine. And what I said was maybe the origins of this Islamic repugnancy clauses or Islamic supremacy clauses goes back to this doctrine of Siyasa Sharia that kind of continues to influence how Muslims think about incorporating Islam. That was the point of the origin. So I hope I was able to clarify that.
Oh, thank you, Professor Pasarlay. Okay, we still have a little time left. So actually, I have a question, that kind of like an external question. I hope it wouldn't be posing that like too unfair, because I understand that the kind of things that the motivation of this book, you try to debunk the kind of like a common assumptions that that there's this tensions between Islamizations and constitutional. So there's a theory from political theory. So from John Rawls particularly, he said something about public reasons. All right. So he said constitutional interpretation has to be use public reason. By public reason, he means that reasons that everyone in the society can endorse, right? So I guess this is something that the democratic theory felt that there's something tensions between the democratic constitutions and Islam, is because even in a majority, in Muslim majority kind of community, if the interpretation of constitution finally resort to certain of a religion's doctrines, then how that kind of decisions, which ultimately connect to the coercive power of the state, would be able to be endorsed by people, for example, the minority, religious minority, for example, Christians, right? In some of these Muslim countries, in Iran, for example, there are some, many, in the Middle East country, they have a Christian minority. Then how this kind of interpretations that resort back to Islamic doctrines would be able to accept that. I guess that is like a more like a theoretical kind of challenge. Maybe it does not play well with the empirical evidence, but I think that is what it comes from. So I would like to hear more from Professor Abbasi about this point.
So Teng, this is excellent point, and I think I would refer to the work of Professor Clark Lombardi about Pakistan had a Catholic Chief Justice, A.R. Cornelius. Yeah. And A.R. Cornelius was the one who called for Islamization of Pakistan's constitution simply to embed constitutional values in Pakistan's society, which is Muslim majority society. And the argument was that by embedding Islamic norms, it will ensure consistency, and it will also put a check on authoritarian regime. So when there was first military coup in Pakistan in 1958, army commander actually abrogated the constitution and then set up his own government. And his action was challenged before the court. And at that time, we had Cornelius as one of the judges. In majority judgment, they say it was based on Kelsen's theory of successful revolution. Successful revolution has happened, and that revolution has become a Grundnorm in its own right. Cornelius wrote a dissenting judgment, arguing that a coup cannot abrogate constitutional rights because they do not come from the state. They are based on natural law. And because Pakistan's Grundnorm was not the coup, but it was more of primordial tradition, more of natural law tradition, where rights did not originate from the state, but they came from something which is extra state. So natural law tradition. So basically what he was arguing that because Islam was embedded into the Pakistan's constitutional structure, and then in later on, Supreme Court held that Islam is the part of basic structure of a Pakistan's constitutional setup. So the whole argument was that more Islam does not mean less rights for people who are not Muslims, say, for instance, Christians or Hindus. Because when it comes to fundamental rights, the basic rights, right to life, liberty, freedom of speech, they are endorsed under Islamic law. Of course, there are some restrictions, specifically when it comes to freedom of religion, conversion from Islam. But when it comes to the basic human rights and fundamental freedoms, it's not that Sharia principles or Islamic law principles and human rights tradition, they are mutually exclusive. What we try to show in our book is that this whole argument that human rights and Islam, they are mutually exclusive. So one is secular, another is religious. And I think current scholarship about Islamic law also shows that this distinction between Islam and secularism is also false. So the most recent book, Islamic Secular, by Professor Sherman Jackson, puts this argument, and as Shamshad also mentioned, so the doctrine of Siyasa Sharia is basically an Islamic notion of secular governance. So the argument is that governance, in its essence, as political organization of a society, is neither religious nor secular. It is very much neutral. And Siyasa Sharia sort of endorses that arrangement. And those of us who want to conceptualize the Saudi political system and constitutional system is actually based on distinction. So religion to ulama, so they have ulama council, and politics to the king. So give Caesar to what belongs to Caesar, and then give the clergy what belongs to the clergy, and their relationship could be symbiotic. So what has happened is that in most of the academic and popular discourse, Islam and human rights, Islam and secularism, so these were the binaries, and we try to dissect these boundaries and try to show that actually there is much more here, rather than having these mutually exclusive binaries. I think you're muted. Thank you.
Thank you. Oh, on that note, we overrun a little bit, but there's certainly a fascinating conversation that that could still go on for an hour, but we have to stop because it's really late, especially for Professor Farsley, I know. So thank you very much to all of you for participating today. Please join me in thanking our speaker today for sharing their thoughts on the book, as well as the themes that arise from the discussion. I hope to see you again discussing your next project. So thank you very much. Thank you for being here. Bye-bye.
Thank you, Dr. Teng. Thank you very much, everyone.
Thank you, everyone. Good to see you all.
Thank you.